Good afternoon, everyone. I am Bill Frumkin. I'm a partner at Frumkin and Hunter, PC Law, and we are going to be having our the beginning and this an enjoyable hour and a half of our program, which is going to be in the COVID-19 trenches, navigating privacy, concerted activity, bargaining, and employee gag issues for the labor law practitioner. The focus here is going to not just be on what should be, but really on what is actually happening and how to deal with those issues. And we have an esteemed panel for that purpose. Now, before we go into their description of them and a little more into the program, just a few housekeeping issues. First of all, on your screen, you should be able to see that there is an icon for handouts, and there's an icon for the CLE form to get credit. Okay, so it's important to print out those documents if you want to receive them. And obviously, with respect to the getting credit, that part will need to be completed with a special CLE code, which I will give in the last 15 minutes. So it's going to be very important to hang around for that code. That code is under wraps and is not being held for confidential purposes by the people who utilize Trump's tax returns. Okay, so this is really going to be secret and no one's going to be able to get it until the end. So stay tuned for that. The next issue is if you want to ask questions, there is a question box. So that is where you will write your questions in, and we will also be sure to answer them as they come in. That's going to be the goal, to have more of a discourse than just having people speak. So feel free to please ask questions, but the questions must go in the question box as opposed to the chat box. Okay. Now we have broken our program essentially down into sections. First, we're going to deal with collective bargaining and all of the issues related by two very esteemed practitioners. The first is, actually they're going to go together. Gwen Wilcox, who many of you must know, is a partner at Levy Ratner, a well-known union side firm. She has worked for the NLRB along the way. She has lectured and spoken, and her claim to fame is representing 1199, which here in New York, which many of you are quite aware of. Now, on the other side of that panel with extensive experience is Marshall Babson. Marshall is counsel to St. Farth and Shore. He has also worked for the NLRB. He has over 4 decades of experience, and his claim to fame is being a member of the NLRB under the Reagan administration. And I've come to know Marshall through preparing for this and other times, and that he is also going to be a great speaker. Now, moving right along, we're going to have Mark Pierce is our next speaker, and Mark is going to speak about collective bargaining with respect to specifically privacy issues and issues related to that in the workplace. Mark, as many of you should know, was the chair of the NLRB and a member of the board, obviously, during the Obama administration, and has been very active in our college programs in the Second Circuit. So many of you know Mark, and we're really fortunate to have him. He also is from Buffalo, and you must be happy that Buffalo is 3-0. And I am quite sensitive because I am a Jet season ticket holder, which I don't admit readily, but I am here. Okay. And finally, we have Alan Simonet, who's actually the current vice president of the college, in addition to being a very well-known arbitrator and mediator in various panels, and is known and written extensively on the topic, and is really an overall good guy. Alan's mistake was telling me that he was heavily involved in the MLB umpire strike, the Major League Baseball umpire strike. So I hold him accountable for all bad calls given against the Yankees, and he knows that. I told him that. So having said all that, and without further delays, why don't we begin? I believe Gwen is going to start us off. And again, I just want to encourage questions to be asked along the way. Thank you, Gwen.
Okay, thank you, Bill, for our wonderful introductions. And I am going to start off the program today, and I'm fortunate to be able to have the opportunity to have discussions regarding bargaining with Marshall Babson. And our discussions really are going to focus on bargaining issues during COVID. And as Bill has mentioned, you know, most of us are all from the East Coast. I'm only, you know, from New York, but we've, you know, obviously have, you know, worked and lived under COVID. And we are, still in the pandemic, but there were obviously surges earlier on in the year. And, unfortunately, there may be additional surges going forward. As Bill mentioned, I represent 1199, and they have offices and members in New York State, New Jersey, Massachusetts, Maryland, DC, and Florida. So as we sat in New York, trying to figure out how to address the daily changes and issues arising with COVID, we also, now are somewhat in better shape in New York, even though there are some upticks in some areas of New York. We, now we're looking at Florida, and certainly we learned a lot based upon the experiences dealing with New York and more northern states. And Florida is now one of the hot zones in the country, as well as many other states. So, obviously we're not out of the woods yet, and this pandemic continues. But one of the things, what have we learned? And one of the things that it really comes back to me all the time is the fact that it was really important that unions and employers communicate. Communications cannot be underestimated. Obviously, we're concerned about representing the employees that we represent as a union, but at the same time, we're also, the communications have to be with everyone within any particular institution. And that need to communicate may also require the need to negotiate with the union as well. And, so far, there's so many issues that have arisen, but, the bottom line is that everyone has some level of fear, some more intense than others. The employers want employees to be able to feel safe about coming back to work or working under COVID circumstances. And so those discussions with management, frontline supervisors, and workers, you really need to be consistent. It needs to be regular. And nothing can really replace the fact that with the union, there's a way in which the communications with management can also supplement anything that management is explaining and communicating to their workers. And as already mentioned, the issues around COVID change daily. The requirements, constantly change. Here in New York, fortunately, Governor Cuomo had his daily briefings, as he did today. He issued executive orders. Laws were passed to address COVID issues, such as in New York State paid sick leave. Then the New York State Department of Labor would have to issue guidelines. The New York State Department of Health would have to issue guidelines. They would have to update their websites. And, this was kind of like so many different treadmills going at the same time. And oftentimes through no fault of anyone, information, sometimes it didn't come out at the same time. Some of the information might be conflicting from one agency to the other. And one of the key factors is that as the union is involved in a lot of those workplace issues, they were in the position to be able to point out issues that might have gone unnoticed in terms of the Department of Labor and Department of Health. And so it's really critical. I'm, as a union lawyer, I see the impact of how unions can be effective communicators and also help address the issues that I think we're all concerned about. We're all concerned about making certain that we're all safe, whether it's our patients coming to a hospital or whether customers coming into a store. Whatever the industry is, we all have an impact, and it's obviously not just the workplace that we're providing for, but also the families that are there that workers have to go home to. And so I just want to recognize the fact that I'm sure so many of you are working or representing members and clients in various industries. And so it's really important to obviously, keep up with what's happening. While there were daily changes during the surges, and also with regard to the CDC and OSHA. Things have calmed down a little bit in states where they're not a hotspot, but it is important to know what those guidelines are and laws are, because that obviously will impact the decisions that both the union and employer are in the position of and discussing. So, one of the things that I think the timing of this panel was really on time is because the NLRB had issued NLRB General Counsel issued a memo outlining decisions and during COVID. Those were decisions that, and that memo issued on September 18th of this year, and that's part of the materials that are part of the materials for this webinar. Prior to September 18th, there was a prior memo which looked at how the parties might consider addressing non-COVID emergencies. There was obviously precedent before about how to address emergencies that were of a public nature, such as hurricanes and other weather type of conditions, but also issues that also were emergencies maybe for an individual employer as opposed to the broader community. So now that we have lived under COVID, in terms of the obligations to bargain, there are a myriad of issues, and we're going to try to stay on our course for this program, because the College of Labor and Employment Lawyers actually has had some really significant programming. And in particular, I want to point out the September 21st and September 24th webinars, one having to do with the return to work issues, workplace issues, because I think many of us are still working even though we're not in the workplace. And secondly, remote work. What are some of the issues many issues that are posed by returned remote work? So those are available on the college's website, because they were in fact recorded. So looking at some of the issues that really came about initially were the issues having to do with once COVID hit, were furloughs and layoffs and other such big ticket items. And they would, again, it's really, those issues required the parties to look at the collective bargaining agreements to determine whether even though the parties never addressed COVID in their contracts, what were the criteria for layoffs and who would be laid off and so forth. So, looking at the collective bargaining agreement is obviously the first place where all of you would start. And I, just want to recall a situation where in a small clinic that took care of patients, physicals and other, just regular medical care, during COVID, they no longer had patients, because only patients that were coming, any patients who had COVID went to the emergency rooms. People who didn't have COVID didn't go to the doctor. And so they were faced with the fact that they no longer had patients coming in, and under their contract, the collective bargaining agreement, they had the right to lay off employees, and not knowing how long this would be. And it was hard to forecast what the circumstances were. But at the same time, if this was going to be a long-term layoff, the employer would have to then pay severance pay. If they had to pay severance pay without any income coming in, they would have had to file for bankruptcy. But the union and the employer were able to bargain and work out an arrangement so that employees were going to be laid off, but at the same time, there would be, there was language about how they would be recalled to work when certain circumstances would arise. And under, the supplemental legislation that provide for pandemic unemployment, employees would then be able to collect unemployment. And so the severance issue became a little bit, was not as critical of an issue. So the issue, that's the way that, if there was not that cooperation and understanding, one employer and probably many more would have been no longer in existence. And, and and in addition, to the extent that you have, there are collective bargaining agreements that provide for training funds and job security funds in particular industries. During the pandemic, hospitals and nursing homes were looking to hire, particularly anyone who was qualified, and those funds were very critical in terms of working with the human resources departments to identify potential candidates and get them in touch with those nursing homes and hospitals, because there was a dire need to employ employees, some of whom were being hired on a temporary basis, some being hired on a permanent basis. So that cooperation is so critical. So prior to the pandemic, the standard was that, and still is, that if an employer is faced with an unforeseen emergency situation, then they have the right to make unilateral changes that are related to the emergency situation. I say now, after living under COVID for 6 months, it's no longer an emergency. It's become the new norm. Hopefully it won't be the new norm forever. But so I think it would be very difficult for an employer to say now that that the pandemic is unforeseen, even though there may be upswings and downswings on the impact of it. I think that's a question that but I do think that it's not an emergency as it was in March when we went into this with our not knowing what to expect. And then that emergency, those changes have to be reasonably related to the emergency, so that you have to look at whether those unilateral changes were material, whether it's substantial, and what were the significant adjustments. An employer nevertheless has the responsibility of sitting down and bargaining over the effects of those decisions. However, I urge you, for those management lawyers in the audience, that under the best of circumstances, that even if your clients do not have the obligation to bargain with the union over unilateral changes, they should, because for the reasons that we all need to make sure that we have the same information and learn from the best. So I know that they're the best lawyers out there, the best HR directors and medical experts that are being relied upon by employers. But the union and the workers are really in the trenches, talking about being in the trenches. And they can often make very practical and helpful suggestions. And they're looking at a union that is involved in not just with that particular employer, but has a really an industry-wide view of what has happened under COVID, and understands the industry can be very critical to the success and the continued operations of employers. So pre-implementation negotiations can be helpful. But you should be open about those, even though you have the right to do it. That you should be open about whether those issues that you want to discuss with the union, and you have to be consistent with giving notice and getting input from the union. In one case that was cited, the employer waited 2 weeks. That was an emergency, but they waited 2 weeks to tell the union of the unilateral change. So really, was there really an emergency? And I just want to flag the issue with regard to MV transportation, which was a very significant change in labor law. And so that we all, for those of us who have grown up under the NLRA for so many years, there was always an instance that a union employer could not enter into, unilaterally change an issue that unless the union had clearly and unmistakably waived its right to discuss or to address those issues with regard to mandatory subjects of bargaining. And now that standard, which was issued by the board in September of 2019, they now adopted a contract coverage standard. And so it has changed the landscape in many ways with regard to what's covered by what an employer can do. But you know, I just want to beat the drum on this, that so because you can do it doesn't mean it's the thing to do under COVID. And it's important then to have those discussions with employers, with the union and their employees. And of course, if the collective bargaining agreement has already expired, and the management's rights clause is no longer exists, because that's what gives the employer the right to be able to make unilateral changes based upon looking at the terms of the management's rights clause, unless there's something else that's covered by this contract that would preclude them from doing so. That if that contract's not in effect and there's not been an extension agreement, then in fact there's no defense. I mean, that's not permissible. So again, an employer would still have to bargain over the effects of it. So
I'm just going to jump in, Gwen. I'm sorry. Maybe switch over to Marshall to give the employer perspective.
Okay, great.
Marshall?
I was enjoying myself listening to Gwen. So let me just thank my friends and colleagues on the panel. Thank you for asking me to join you today. I'm delighted to join all of you who are participating. I know we're all making adjustments to this new or different way of communicating. There are some important issues, I think, to consider and discuss. I was thinking about my general comments before the beginning of the seminar today. And one of the thoughts that occurred to me is that if you are someone who does not believe in collective bargaining, this is not the seminar for you. Okay. So people can have disagreements about what topics are subject to bargaining. I think Gwen did an excellent job of outlining some of the topics that have come up. I want to highlight a few that have been prominent in our practice in the last several months. But the key here is collective bargaining. It is still the policy of the United States to promote collective bargaining. Perhaps at the end, we can talk about some of the changes in board law and how consistent they are with this overall policy and purpose. But clearly, it is a key component of dispute resolution at this critical time in our country and in the world. So there are really four areas that I really would like to focus your attention on that have come up that I think are worthy of consideration. First is the issue of hazardous pay, which also relates to the assignments that are made and transfers if people request them pursuant to a collective bargaining agreement. Almost without exception, employers with whom I have worked in the last 6 months who are in the logistics industries or in the logistics business, whatever slowdown there's been in cultural activities and hospitality, restaurants, hotels, we all know from our experience that the workers and the companies that for whom they work that deliver goods and services to us have become key components of this economy. And so one of the first issues that has come up is hazardous pay. If you have in place a collective bargaining agreement with a collective bargaining representative, and the collective bargaining representative comes to you as the employer and says, we want you to bargain with us about paying hazardous pay. We understand that there's no provision for it in the collective bargaining agreement, but we want you to talk to us about this issue. It seems to me that it's in everybody's interest to do that. Whether or not you have an obligation to bargain about a particular issue. We know that if the topic is covered by the collective bargaining agreement, that you arguably do not have an obligation, that both parties have to agree during the life of the agreement to change or alter a term of the contract. If the topic is not addressed in the collective bargaining agreement, we know that there is an obligation to bargain in the absence of a zipper clause, which would preclude that. But I want to flag for everyone, I think that it's a mistake to not listen to the collective bargaining representative. Again, what the employer may or may not be willing to do, under what circumstances, what criteria should be established, that's to be determined. But in any event, I think it is important with regard to these issues of hazardous pay, assignments, and transfers for people who are being asked to continue to work during this difficult time, even with some of the improvements that have taken place in some jurisdictions. It behooves the employer to sit down at the bargaining table, absent some clear language that would indicate that there is no such obligation. A second area that has drawn our attention is visits and inspections by the collective bargaining representative. And we have had a couple of cases, one of which went to advice, in which the collective bargaining representative argued that the union had the right to make effectively unannounced visits to the employer's location to determine whether or not there was adequate compliance in the representative's view with COVID observation and practice techniques. Again, most collective bargaining agreements have provisions that address whether and under what circumstances inspections or visits may be made to police a collective bargaining agreement. Very few have language that is so specific with regard to this particular issue. I'm not sure what my camera is doing here. Let me just do one thing. I'll be right back. There, maybe that's a little less interference. I apologize for that. You crazy. It was driving me crazy. So I apologize. So the issue is, does the language of the collective bargaining agreement deal with this question of unannounced visits? And we had employers who would say to us that, look, we're concerned about introducing a non-employee who has not been through our protocol training program to come in unannounced and expose himself and others to whatever he or she has been exposed to themselves in terms of COVID. So this is a case that was filed in Region 21 in Los Angeles, went to advice. The bottom line, it may not be, and again, these are very fact-specific questions that often turn around the collective bargaining agreement, the language that's specified in the agreement. But in our particular case, the employer had offered to allow the union to come visit with 1 hour of notice. And that 1 hour was not intended to go around picking up the pieces of an ill thought out COVID protection plan, but rather just to plan ahead so that it, one, did not interfere with operations, because most of these, for example, logistics companies are quite busy right now. And two, that there be an opportunity to make available to the collective bargaining representative whatever information is required in terms of PPE and other protocols and procedures related to the safety and well-being of the employees. To ignore the request, to simply deny it out of hand, it seems to me, is to, as I indicated at the outset, to undercut in many ways, and as I think Gwen, appropriately underscored, the very purposes of collective bargaining. So listen, if you don't agree, you don't have to. We know that's one of the hallmarks of the U.S. system of collective bargaining. Agreement is not something that's required, but I do think listening is helpful. A third area in which, and this is going to touch a little bit on what my good friend Mark Pierce is going to be discussing. And when it comes time to ask questions, by the way, I want all of you to ask Mark who the gifted artist is who painted that beautiful painting behind him. So he may share that with you. And this is the issue. This is the question. This is the question regarding what information must be provided to the collective bargaining representative regarding bargaining unit people who may have become infected. So to put this in, and I may be the odd person out on this, and again, I would invite the comments or questions of not only my colleagues on the panel, but our distinguished attendees today. Just to put this in stark terms, we had in our law firm, we had an individual lawyer who was diagnosed with COVID. This is early in the pandemic in March or April. When people asked, who is it? Firm management decided that they wanted to protect the privacy of the individual and they didn't feel any need to share that, which I understand. There are certain privacy obligations and responsibilities. On the other hand, people who may have come in contact with this individual might have appreciated the opportunity to learn that somebody that they had been in close contact with during the preceding 14 days, in fact, had become infected. And the firm's answer, again, please forgive me for, I'm not chastising people, I'm just pointing out the differences of opinion. The firm's response was, well, we interviewed the infected individual and asked him or her to tell us everybody with whom they had come in contact. Well, guess what? I'm not particularly interested in somebody else's recollection of the 40 people that they happen to come in contact with if they forgot number 41. And if I'm number 41, I may remember that I had a long chat with that person in the hallway that he or she forgot about. So these are tough issues, but we've had a number of them that have arisen in the collective bargaining context. Tell us who it is who has become infected. Tell us who, in your view, has been in close contact with that individual so that we can effectuate our role as collective bargaining representative and help that individual protect himself or herself.
Marshall,
I will tell you that,
Marshall,
yes,
I was going to say that you have about 5 minutes. I just want to know because you have another point to make. And
yep, I will. I appreciate it very much. And I'm just going to flag the last area for you that I'd be interested in people's comments. So clearly information is extremely important, as Gwen has pointed out. This is one of the essential components of the collective bargaining obligation. Think very carefully before you say no or hell no with regard to the information that is requested. Is it something that's reasonably related to the union's role as collective bargaining representative? It's a broad standard. It's not relevancy, it's not materiality. They're reasonably related to the union's role. The last item I wanted to flag for you, several collective bargaining agreements that we've been involved with have force majeure clauses, particularly in the area of theater, orchestras, operas, ballets, and so forth, which, if you will, depending on the language, a particular force majeure clause, raise questions as to whether or not COVID is what the parties intended in writing a force majeure clause. Of course, the language of the clause itself will have a variety of provisions in it. And its most extreme instance it will have a provision that says that the terms, and we had one like this in San Francisco, the terms of the collective bargaining agreement shall be set aside. And the parties have an obligation to bargain new terms in the instance of a force majeure that prevents performance. So again, how these clauses operate, what, if anything, the parties do, as Gwen, I think, wisely pointed out with the employer who felt that they were in financial distress. Sitting down at the bargaining table is often an avenue that will produce results that you may not have imagined before a difficult situation like this. So with that, I'm going to stop and look forward to your questions and comments.
Thank you. Okay, I'm going to pose a question that really has been maybe sort of implicit in your and Gwen in your remarks, and I would invite Alan and Mark to join in on this as well. We have included as part of the materials an article that was written in late August, and it's in the U.S. Business News for Bloomberg Services, and it's entitled "Gag Rules Stop Workers from Talking." Okay, and on that's not the name of the article. It's not the picture, but it says, "Attention employees, please shut up and work." Okay, and the gravamen of the article essentially is that we all have, all companies have great policies about privacy, about you name it. You know, when someone says they're affected and someone says not. However, when people complain, to some degree, it's been falling on deaf ears. And I suggest everyone read the article, but just to sort of go around here, maybe we could start, Gwen, about what advice you would have for union counsel in a situation where people are complaining that, you know, the employer is not really helping them when they complain about their own safety issues. Marshall, from your perspective, guidance to employers, and Alan and Mark are sort of here as neutrals, but we'd like to hear what they have to say. So you want to pick up on that, Gwen?
Yes, thank you, Bill. And Marshall, thank you for your comments as well. I really, really join you with many of the things that you have spoken about. And so I think in this, you know, the position of employers who want to keep secrets about what's actually happening with regard to COVID and its presence in the workplace has, you know, can violate executive orders, depending what states they're in. It can violate Department of Health guidelines, and you know, and ultimately, it's not protecting anybody but the employer, who may end up really being in situations where they have a workforce that is really contaminated. You know, that people are, you know, going to have widespread use of COVID. Getting contaminated by COVID. So I think if a union that's placed in that situation, knowing what is happening there, they have to utilize their whatever language is in the collective bargaining agreement to sit down and talk with the employer about this, and use whatever pressures that are necessary to challenge that really short-sighted decision. Not to say that employers aren't looking; they may have a good reason, but it's really not protecting people. So I think it's another opportunity for collective bargaining to be put to the workplace.
Marshall?
Well, I think this is an area where it's easy for employers to get misled or to misunderstand. I would say to someone who doesn't want to listen to his workers, have we learned nothing in the last 85 years? You may agree, you may disagree. You can say no, as we know, and as I said earlier, as part of our U.S. system of collective bargaining, but to not listen is not helpful. One of the cases I know that I was involved in when I was at the board, it was a while ago, of course, was NUMMI. This was the joint venture at the time between General Motors and Toyota, in which they adopted the so-called Kaizen work environment, in which the whole purpose is to allow workers to filter up to management and supervision ways in which the process and procedures can be improved. So the idea that you can be successful in your business and tell your workers to keep their mouths shut. It's just not, I don't understand it. I truly don't.
Hey, Mark, I know, Mark, this is a major topic of your program, but I know you can handle this without, revealing too much.
The thing about it is there's certain things that are just basic to labor law. I mean, we learned about the Supreme Court weighing in when truck driver James Brown said that the brakes are not working properly in this truck, and he was retaliated against because he complained about it too much and was refusing to drive the truck. Now, the problem, and I think it's articulated somewhat in some of the scenarios that were laid out in the General Counsel's memo that is provided in your materials, is that you can't retaliate against people because they're expressing concerns about safety, because safety concerns by groups of employees, as we all know, are indicative of concerns about what the terms and conditions of employment. And to try to clam up people in advance is going to be problematic, and it doesn't bode well for the transparency that is necessary for a collaborative way in which to address a problem that is very unique and needs the cooperation of everybody concerned.
Now, before I didn't indicate that Alan is going to really speak about, arbitrating matters in the pandemic. So with that perspective, Alan, can you have some comments on this issue?
You're on mute.
Yeah, you're on mute, Alan.
I know, I'm muted. I wanted to keep my mouth shut as long as I possibly could, so I muted myself. So, but I was very struck by Marshall's discussion of what happened in his law firm, because it kind of brought out in stark interest the interests that are that both parties have in this instance. COVID is a community disease. It impacts not just the individual, but it impacts the community as well. So you have what I would call conflicting interests of the need for the employee to maintain privacy. And I think in some cases, employers may be a little, let me use the word paranoid, about whether to disclose certain information about the privacy of an employee. At the same time, though, there's an interest in the community. And the union represents the community in the collective bargaining situation. And so it's in the representative's interest, in order to keep the community informed of what the health status of the workplace environment may be. Now, when I was thinking about that, and from the dispute resolution angle, there are this is one of these areas in which parties can come together and either arbitrate or even mediate to come up with some type of protocol in order to disseminate this information to meet those interests. I think about that because I don't know if this is a great example, but I remember getting in discussions with parties over issues where there's a proprietary interest for whatever reason, and the employer doesn't want to disseminate that information. But the union, because of what they have to do and what employees have to do, have a need to know this information. So sometimes you have to kind of negotiate or mediate a protocol in order to handle and make sure that those interests are balanced.
All right, Mark, we're going to give you the floor now. Your remarks about privacy and anything related in the collective bargaining context.
Well, thank you. And greetings to everybody. This has been a fantastic discussion so far. I hope I don't drop the ball in terms of interest. Privacy considerations are significant in terms of when COVID impacts how business is being performed. And my talk is by no means an all-inclusive recitation of the concerns that you might have to have. But needless to say, there's a delicate balance that has to be drawn between an employer's right to run a business and to ensure safety in the workplace, and the right of employees to keep the employers out of their business and out of their private lives. COVID, because of its unique impact, is tipping the scales in favor of more increased intrusion into the matters relating to employees' health, given the threat presented by the disease on the bargaining unit as a whole. Now, unions have a healthy concern that COVID might be used as a get out of jail free card for employers that want to take advantage of this, and the unions are expected to take the appropriate precautions in that regard. Another wrinkle in the circumstances and assessment is that there are government mandates that have been imposed as a result of COVID that may well override typical protocols that are set forth in a collective bargaining agreement. And the union and the employer, even in those situations, do have a duty to meet and confer, though the increasing level of government mandates may limit what the union can bargain over the decision about. There is still an obligation to bargain over the effects. And as has been suggested by both Gwen and Marshall, irrespective of what is the legal requirement, if there's an overwhelming, overriding concern of mutual benefit, then the union and employer may want to sit down and just hash things out, irrespective of what their technical legal obligations are, because of what kind of protections can be developed as a result. Now, active insistence on effective collective bargaining should be expected. NLRB law is currently being interpreted in a way, however, that causes unions to have concern. Gwen mentioned MV transportation. We don't know the extent to which MV transportation may be impacting things in the future. Needless to say, unions as a result are concerned about waiving their right to bargain over certain things, so they're going to jump on top of things and want to bargain over them before they possibly, based on an NLRB interpretation of the law, lose that right. Unions are going to be concerned about interrogations over activities that would otherwise be protected concerted activity under the guise of inquiring about covert infection and exposure, which means that all sides need to be familiar with the employer's privacy obligations through seeking information from agencies that render some of these guidelines and policies, and oftentimes have explanations as to the extent to which these policies can be probed and promulgated. Now, an employer's obligation, since the issuance of an OSHA memo in May of 2020, indicates that the employer needs to evaluate and discern what might have been work-related in a situation where an employee has been infected rather. So, and if there is work-relatedness to the infection, the employer has a duty to put together a record in that regard in a specialized form that is provided by OSHA. Considerations for assessing work-relatedness can be complex. The employer has to take steps that are reasonable. They have to ask questions to employees that don't infringe upon the employee's rights to privacy. and of course their rights under the National Labor Relations Act. They may ask how they believe they contracted illnesses and discuss their work-related activities that might have given them exposures both inside and outside the facility. And I stress work-related activities because the determination is whether or not there is work-relatedness to the infection. Certain inquiries, depending on how they said, could be problematic with respect to employees' privacy rights not to be interrogated about who they're associating with. They might be at a bar talking with a business rep about possibly filing a petition. And if the employer wants to make inquiries as to who was at the bar and what you're doing, et cetera, that could go over the line. So those kind of situations have to be pursued very carefully. Unions have and will and possibly should sit down with the employer and negotiate an opportunity for the union to have a steward present during these discussions. Of course, that kind of permission would have to be with the consent of the employee, because the employee may reveal or may be asked to reveal information that the union should only have access to if the employee volunteers it. So there are a whole host of complexities that get involved. Now, when an employer is discerning work relatedness, they have to consider evidence that is reasonably available to them. They don't hire a detective and start digging around, but they can consider after acquired evidence after they've made a determination as to whether or not there has been work relatedness related to the infection. The evidence that the COVID was contracted at work, absent an alternative explanation for the illness, may include incidents of COVID among several employees who work close, illness after close exposure to a customer or a coworker with a confirmed case. The employee's job duties include frequent close contact with the general public or in an area where there's ongoing community transmission. Now, there's evidence that may weigh against this kind of work-relatedness situation. The employee may always work remotely and is not in contact with other employees, or may not have to go into the public for work-related purposes. Therefore, there may be arguments as to why work-relatedness is not appropriate to conclude that that's where the infection lies. In California, however, there's a presumption that there is work-relatedness when the infection occurs, and the employer would be obligated to rebut that presumption in order to determine that the employer is not responsible. The key is transparency, where workers knew about the surveillance. And I'm sorry, I'm jumping ahead. Sometimes there are surveillance devices that are being used to make a determination with respect to whether there has been contact. Those surveillance devices can be problematic, obviously, because they could be unfair labor practices and that they infringe upon employees' rights with respect to terms and conditions of employment and can be coercive. However, if there is a protocol established with transparency where the employees participate in these things, there are ways for these things to get accomplished.
Mark, I'm going to jump in, and we do have a question, for you, or for anyone, I guess, for that matter. But basically, the question is, the EEOC's provided guidance that under the ADA, an employer may not disclose the identity of the person who tested positive. The question is, please discuss the situation where the union insists that the employer provide the name of the person who tested positive.
Well, there is a concern, of course, and while the employer is not controlled by HIPAA, the employer's activities are controlled by, as you indicate, EEOC, and it would be an ADA violation if the employer, without the employee's permission, reveals the employee's specific identity. However, the employer can communicate to the union by generic means and circumspect language the degree of potential exposure the individuals in the bargaining unit have based on information that they have acquired, and would recommend that the union convey to the employees, and that they communicate directly with the employees measures that need to be taken in order to ensure containment of the virus. So protecting the identity is something that the employer is obligated to have to deal with. Now, Bill, I had given you one question that I'm going to jump the gun and get into, because it's kind of illustrative of what the union's circumstance may be.
Yes, and that does speak to the question that was asked about the union's responsibility. They have about 5 minutes to handle that important question.
There was a scenario that was presented to several union attorneys about a situation where a member told his local union that he tested positive for COVID, and the member called out sick from work, but has refused to tell his employer that he tested positive despite the union encouraging him to do so. The question is there anything prohibiting the union from telling the employer that the member tested positive so that other employee members can be protected from the risk? One union attorney's answer was, well, the union should not disclose because the union may be liable under Title I of the ADA, a derivative liability that the employer would have, and that the union needs to proceed with caution. Another union attorney gave a more detailed response, saying that the union should disclose in order to protect the workforce it represents, because the union has already suggested that the employees should report this to the employer right away. The union should advise the employee to report the test results to the employer as soon as possible. The employee should further be advised that failure to do so puts others at risk and could be a basis for serious employer discipline. Moreover, the employee should be told that if he doesn't make the report, the union would have to disclose the information to the employer, because it has an obligation to protect the employees in the bargaining unit to make sure that there is safety and health concerns dealt with. It could be also exposed to possible financial claims by others who could become ill with COVID because of contacts with the employees, which the union had knowledge of. The employee should be ensured, however, that the union would be an advocate for the employee to make sure that the employee is not retaliated against and is adequately protected. But the union should not be concerned about so much ADA violations, because there is an overriding consideration in terms of protecting its membership and the concern about the liability that the union would have if it didn't disclose. I throw that out to the rest of you to see what your opinion is of this, whether or not this attorney got it right.
Anybody else have any comments there?
Well, let me just say this. I could not agree more with what Alan said earlier and has been suggested by Mark. Um, Notwithstanding the EEOC guidance and so forth, I mean, you'll forgive me for saying this, but we've all heard the expression, the law is an ass. It is in fact, and has repercussions well beyond the individual, as Alan had said so well. It's a community issue. In this case, the community is the bargaining unit. And I mean, I dare say one could, I think, make out a fair argument that it's a violation of the duty of fair representation for the union not to look out for the well-being of the larger number of bargaining unit members. So some of these more indirect means of both cajoling and assuring or reassuring the affected or the infected bargaining unit member, I think, are well placed, and that we need to keep that in mind. This, just to remind everybody, and we have, again, I know, a distinguished group assembled here today, but this is not the first time that an agency or department issues guidance or instructions that are arguably inconsistent with another agency or department's portfolio. And so, notwithstanding the fact that if you're an EEOC specialist, you think that that reigns supreme. Yeah, as Mark has pointed out, I think very eloquently, there are compelling other considerations to take into account with regard to Alan's community, which I certainly agree with.
Yeah, I'm just going to take the moderator's prerogative for a moment to say that the crux of the article dealing with the gag order is that these policies that exist at a certain level, one reason or another, don't always filter down into the line worker, okay? And the sort of horror stories that have come up in this article, particularly with OSHA, in that there's no private right of action, or OSHA has to bring the case. The board has looked at some of these cases, giving employers a lot of discretion, et cetera. It's a real quandary for the balancing act, and that if the guidance doesn't seemingly protect the employee, and when it filters down to what happens day to day, doesn't protect the employee, and the employee's only remedy is to file charges with necessarily agencies who have a different bent than maybe there has been in the past, then people are left without any remedy. So I'm not gonna resolve that, but that, I think, is the day-to-day proposition that's going on. So without further ado, I'm going to let Alan take the floor, to discuss the impact or what's happening in arbitration mediation in the COVID pandemic.
Well, thank you very much for having me. It's such an honor to be on this panel. What comes to mind in these cases is that when I was playing basketball in high school, they would always have the varsity game first, and then the place would be packed, and then they would have the JV come in, and then half the crowd would leave. And so now I feel like, okay, you got the JV now coming in to say a few words, and I'm asking the participants to stick around. And Bill, don't give out that CLE number yet, because you got it, because otherwise
under lock and key, not to worry.
Okay, because otherwise people will leave because the JV game is just about to start. So the way I want to kind of start this discussion,
Alan, because of Zoom, I'm not wearing boots. Had I known, I would have.
So anyway, so the purpose and my role in this panel is basically to identify potential issues that may arise before an arbitrator as a result of bargaining unit employees being called back to work, the question of benefits and wages under the collective bargaining agreement. And I want to kind of start off by saying what Marshall has said about the importance of, and Gwen has said about the importance of negotiation. Yes, negotiation, communication is important. Agreement is not necessarily there. That does not mandate an agreement. So what happens when there is no agreement? And in this kind of situation, my first question was to find out about arbitration processes that can help resolve the disputes in this environment. Now, in many cases, parties may decide to expedite arbitration or enter into mediation, even without contract provisions that provide for that. And in that case, I kind of encourage parties that even if you don't have a expedited dispute resolution provision in your contract, there's nothing that keeps you from being creative. You have a dispute, it's possible to find someone to assist you in resolving it. Now, just to kind of find out what's going on, I informally polled my colleagues who are engaged in expedited dispute resolution under this situation. And there's basically been two areas, the majority of which is in the healthcare industry. My colleagues who I've talked to have identified a number of disputes that have become expedited that have arisen over disputes about PPE and about hazard pay. And I know one of my colleagues in California is involved in a pretty extensive mediation between parties in order to find some kind of protocol with respect to PPE, contact tracing as well, and hazard pay. One example I had from another colleague is that in New Jersey, 1199 and a number of the healthcare institutions have, in essence, set up an expedited panel and asked some arbitrators to be involved, to be available in case these disputes arise. The one colleague I spoke to says that she gave a number of early dates, but today she has not had anything go forward to a hearing, which from an arbitrator's point of view is not necessarily bad news. It means that the parties are talking and the parties are settling and coming up with protocols to deal with these issues. So that is a good thing. The other area that I wanted to raise here is in the area of education, public education in particular. There is currently pending a case in the city of Chicago with the Chicago Teachers Union, and it involves the bargaining unit consisting of the school clerks and technology coordinators. And they are being mandated to report to their schools in person. In this case, the union is challenging the decision based on the health and safety provisions of the collective bargaining agreement. The case has been heard. The arbitrator has been asked to issue a bench decision. The arbitrator respectfully declined, and they're currently briefing the issue as we speak. So my point here with respect to arbitration processes is even if you do have no contractual means negotiated to resolve disputes that may resolve these issues, that there is nothing that says that the parties can be creative and just come together to put together a system to do that. My next area that I wanted to talk about is issues involving the entire bargaining unit. And that's basically what we've been talking about here. Now, from my role, the nature of the dispute is really dependent on the language of the collective bargaining agreement and how that language will apply under these unique circumstances. Now, the general rules of contract interpretation are designed to determine the intent of the parties in adopting their certain language. Admittedly, and I know everyone on this panel will agree, is that the issue, however, is that no one anticipated the impact of a pandemic on the relationship. So generally, absent any specific language, many employers would like to revert to management's rights, that they have the management's rights to do certain things that they're necessary to do business under this pandemic. I say that and I urge employers to use caution here. First of all, from basic contract interpretation, while the management may have the right as far as operating the business, they do not have the right to be arbitrary and capricious. And I think that is very important under these circumstances. So one thing I do urge employers is, and I heard this on an earlier webinar, is to slow down and to engage the union and the representative of the employees before making a decision. Just because you have the right to do it doesn't mean that it is necessarily the correct decision. Now, employers, for example, have the discretion of regarding the operations on contract language. They can determine when and how employees are recalled to work. And absent contract language, they may implement safety rules to address exposure concerns. The question, so there may be a number of questions, and even in the exercise of the management's rights, as Mark basically alluded to, the impact of that exercise may still be subject to arbitration and the impact on specific employees. Let me just talk about one area of contract interpretation that may arise, and that is in cases where, as I said, the contract is negotiated, nobody anticipated a pandemic, and so what is the arbitrator to look to in interpreting vague or silent contract language? And so in many cases, and as many of you all know who are experienced in arbitration, many arbitrators look to the role of past practice. Now, even we have not seen, unless you've been around since 1918, you have not seen a pandemic that may create a practice with respect to doing business. But I submit that there may be other instances that may be considered because there may be other emergencies, instances that may curtail business. And what comes to mind are weather events, hurricanes, tornadoes, those kind of things that may have some impact on how a business is run and how the parties handle those type of emergency situations. Marshall also talked about I wrote this down, about the force majeure clauses and how those clauses are interpreted under these circumstances. My response to that is, I don't know. I have to see one, but I have a feeling that those practices with respect to especially performers, when they are unable to perform for one reason or another, and the force majeure clause is invoked, may be relevant considering the language that you're interpreting. The next thing I wanted to move on to was the impact of health and safety language. There's a lot of language in a number of collective bargaining agreements in which basically there is a guarantee that the employer will provide a safe workplace. And in those cases, the unions have contested whether management has adequately protected the safety and health of employees. And so where there is that contract language, there is an obligation on the employer to provide a safe workplace. There may not be an agreement as to what that means as to a safe workplace. But the contract clauses, and it's been interpreted requiring the company to make every reasonable effort to provide necessary and practicable safety measures, have been construed as constituting what I would call a minimum obligation that the company had assumed for the safety and health of the employee. In other areas, like, for example, whether the bargaining unit should be shrunk, for example, whether employees whether the employer may, for example, reduce the capacity of the workplace in order to facilitate social distancing, for example, is an interesting question that may come up in mediation or arbitration. What employees should be, how employees should be employed or required to come to work, and how are they to be paid? Are they still to be paid as if they're working a 40-hour week at the employer? Will there be a pro rata wages paid? Those are questions that arbitrators may end up discussing. So the next area that I want to talk about real briefly is the impact on the...
Alan, you have 5 more minutes, and then there's going to be a special bonus round of question that no one knows the answer to, that I will be asking.
Oh boy, I can hardly wait for those. So my next point is, and I can almost do this in about 3 sentences, and that is that clearly there are questions of hazardous duty pay. There are questions that may involve other areas like short and long-term disability. What happens with accrued benefits, sick leave, vacation, if the employee does not immediately come back to work. If an employee does not want to come back to work, an employee be forced to take those benefits, take sick leave or vacation in order that they can receive pay while they're out. What happens with leaves of absence policies? If an employer has that as a benefit, when does that accrue in these kind of circumstances? Finally, I'm going to talk about the individual situation in which an employee refuses to come to work because and is maybe forced with charges of insubordination. I think that employers should be very cautious about that, because there is a very big exception to that. And that is, if employees reasonably believe that they are not safe in the workplace, employees can refuse to work, and they cannot be disciplined for insubordination for refusing to do so. That may not be the best alternative for an employer. One idea that I thought about, this is my last comment, is that if employers or if employees refuse to come to work, and I'm not talking about for Mark's purpose, a kind of a collective action. This is an individual employee acting that way. May employers impose administrative requirements? You all have seen cases in which employees cannot come to work for one reason or another, and they're placed on a leave of absence after their benefits are exhausted. And then eventually employers may charge an employee with abandonment and absenteeism. I don't know the answer to that, but I think that may be a question that may arise, especially as employers start ramping up their business and their businesses, and employees have their doubts, regardless of what the employer says about their need to go back to work. So those are the last of my comments, so that we can leave some time for some questions here. Okay, Bill?
Yes, well, what I'm going to do is pose the question. I saw this done on MSNBC once, and I'm going to pose a question to each of you, and you'll all get about a minute and change or so, because we have to save a few minutes at the end for housekeeping issues. So the question is, what do you foresee as the state of collective bargaining in 2021, in the year that's about to come? So we'll start with you, Gwen.
I think that parties will be negotiating. Contracts are expiring. Parties will be anxious to get to the table. Depending on the industry, depending on the strength of the industry, will obviously determine some pretty critical issues during those negotiations. But I don't think they'll be forestalled. I would say in some industries, I'm sure there'll be some that will, try to roll over the contract. But I do think that on both parties' sides, there's some important issues that parties will want to address.
Gotcha. And I say implicit that COVID is probably going to be around, I think, since we're almost in October. Right. So that's kind of part of the question. Okay, Marshall, your thoughts?
I agree with what Gwen said. collective bargaining is not going anywhere. Again, it's very industry specific. Some employers and companies are very busy. There are headlines this morning in the Times about certain businesses that are running ahead of their projections for 2020. And of course, as we know, there are many that are adversely affected, and that will have an impact on the bottom line. One thing that we haven't mentioned, and it's not the purpose of this seminar to go into it, because we could spend an hour and a half at least talking about that, and that's if, depending on the outcome of the election, we have a Democrat in the White House and a Democratic Congress, what impact, if any, of the PRO Act on collective bargaining. If you haven't looked at it, fasten your seat belts. It's quite a collection of proposals, and I think that could have a real impact on collective bargaining. Again, depending on politics, and who knows what the politics are.
Thank you. Mark, your thoughts?
Well, from the privacy perspective, there's going to be a whole lot of issues. Hopefully, we're going to be talking about a vaccine, and the distribution of the vaccine or requirements to take the vaccine, and all of that are going to be issues for negotiations. Also, as I indicated before, the technology is creeping its way into the whole situation. Right now, you got, talking about dogs sleeping with cats and four horsemen of the apocalypse. You got Google and Apple working together to develop a contact tracing app, and when that gets put into place, the question is going to be, what kind of mandates are going to be put into place with respect to requiring the use of the Contact Tracing Act? Because right now, for those apps to be most effective, you have to have participation by the user to input data manually. When we get to the point where this data can just be extracted from you, boy, we're talking about areas of negotiation that we haven't even seen as of yet. So yeah, there is going to be a lot of concern as we go forward with respect to where things are going, and there will be a major need for collective bargaining.
Okay. Alan, your thoughts?
Yeah, just for my 2 cents, I think that the process of dispute resolution is going to change significantly. I think that one, and let's just take the obvious demographic. Most arbitrators are over 65, and some have some type of compromise as far as the health is concerned. So there's going to be some reluctance to travel. That some parties may not particularly like, because first of all, you like the tradition of sitting across at a table in a room and looking the witness in the eye to tell them if it's telling the truth or not. At the same time here, it's going to impact the business of arbitration. Consider this. I have had cases in Seattle, which means I have to plan the day before and the day after to get to the case, hear the case, get up the next morning and fly all the way back. In some cases, I charge a travel fee because it takes a day to get back from Seattle. Back here to Philadelphia. Well, I don't have to do that. But at the same time, parties will have access to arbitrators all over the country. And so there's a large disparity of arbitrator fees, and this has been discussed. It may be less expensive arbitrators may be more available because they have access through this medium, this platform of Zoom. So it may not, so it's possible to get an arbitrator in Missouri, for example, to resolve a dispute. So I think that the business of arbitration is going to probably be impacted significantly. My airline miles are down. I won't, I don't know when I'm going to get to use them, but that's going to be an issue when it comes to day-to-day business.
My free drink tickets are getting stale.
You know, we do have a couple of minutes. I just thought I'd throw out, you know, Mark raised the issue of, you know, the vaccines and, you know, and that availability. And we have, you know, this whole climate of mistrust and distrust with what's going on in terms of science or the lack thereof. Does anyone want to have any more comments about how that's going to affect, you know, the workplace if there isn't a universal agreement on the vaccine working or not? And anyone could grab that.
Well, let me just make this general comment and then I'll make it very brief. So I agree that these points that have been mentioned I think are very important. This is in some ways related to the points that have been raised by Gwen and Mark about MV transportation. Just to refresh everybody's memory, this contract coverage standard is something that Judge Harry Edwards in the DC Circuit wrote about in great detail in the postal workers case. I consider him to be a friend and a colleague. I do not consider Harry Edwards to be someone who's some reflexive right-wing management hack. And you know what MV transportation and other cases I think underscore, as has been suggested indirectly, if not directly, is the importance in collective bargaining of making your language clear. What is it that you intend? And if it's not clear, don't agree to it. But make the language clear. When I started this business 45 years ago, practicing in San Francisco, the head of the firm used to take young lawyers and send them out on arbitrations before they would negotiate. Why? You've lost 3 or 4 arbitrations because the language of the contract is unclear. I promise you, the first time you go into collective bargaining, you're not going to agree to language like that again. Now, we all know that there are difficult topics the parties will bury in ambiguity, but I'm not talking about that. If these are important issues, Bill, as has been suggested, there's a duty on the parties, on both sides, to make the language clear.
It looks like I'm going to have to sort of cut it off. I'm sorry that we won't have a chance to all field that one, but I think that'll be interesting coming attraction. So, okay, so yes.
Please remember to announce the code.
I'm on it. Okay, so here's the CLE code. It's SS9979. Okay, and also it's important to go look on your screen there and make sure that you print out the handout if you want to keep it and review it. There's a lot of great materials in there, and also the CLE form. You will have to put your code down on the CLE form, and there are instructions on the CLE form as to who to send it to. It is not going to Susan. Okay, Susan Wan, we all know. And I think, according to my calculations, we're just about, well, actually, we have 2 minutes. Anybody else have anything to say about this vaccination impact in the workplace? Any more thoughts?
Well, I may have a general thought, and that is, I've always thought that, that an institution we trust uses science that we're supposed to trust to come up with a vaccine. So we're supposed to trust that. I'm not sure anymore. And that, to me, presents a large problem. If you have people that don't trust the science because of some cockamamie theory that somebody saw someplace in the internet, what do you do to convince people to basically trust science anymore?
Mark, any thoughts?
No, I think Alan says it right. I know that there have been NLRB cases where nurses have had concerns about being required to take particular shots in a facility, and those were debated back and forth by different interpretations of the act in terms of duty to bargain. So it's presents an interesting problem.
Okay, I feel like Lawrence O'Donnell now. Gwen, the last word?
We have to, this is just a telescope into the future. And obviously we've learned a lot by the pandemic, but we have a lot more to learn going forward.
Thank you. Well, I think that concludes the program. Thank you, speakers. Excellent work. And
Thank you, everybody.
do it again, as they say. Thank you.
Thank you.